The problem is being investigated. Question time will continue. I call on David Shearer for question number 3.
Thank you, Mr Speaker. To the Prime Minister, does he stand by all his statements?
Honourable Bill English, on behalf of the Prime Minister.
Mr Speaker, he doesn't want anyone to hear these answers.
Does he stand by his statement on the 24th of September last year in relation to GCSB that, quote, "I've never had advice in the 4 years that I've been Minister that they've in any way ever acted unlawfully outside of the advice I received last Monday, which was that they possibly acted unlawfully"?
Honourable Bill English, on behalf of the Prime Minister.
Mr Speaker, yes. And on behalf of the Prime Minister, in July last year, I was told by the Director of the GCSB that a question had been raised by the Inspector General on the Intelligence and Security about the GCSB's assistance to the Security Intelligence Service. I'm advised that this question was raised in the context of the Inspector General's involvement in the review of the NZSIS Act. Lawyers for both GCSB and NZSIS were convinced that their long-standing interpretations, which have been in place for several decades, and their practices were correct. And when the question was raised, the lawyers for both of those agencies informed their relevant directors of their view that the interpretations and the practices were correct. The Prime Minister was not told in July that the activities were unlawful. In fact, as a result of the issues being raised, he was advised that they were lawful. Legal discussions continued through the trial, and that was the case for some time.
Supplementary question, David Shearer.
Thank you, Mr Speaker. Given that he was told in July about the possible unlawful spying on New Zealanders, why did he not immediately suspend any such activity to protect the fundamental rights of New Zealanders?
That's right.
Honourable Bill English, on behalf of the Prime Minister.
Is it going? Sorry, Mr Speaker. Now, could I hear the question again?
Yes, certainly. Would David Shearer please repeat the question?
Thank you, Mr Speaker. Given that he was told in July about the possible unlawful spying on New Zealanders, why did he not immediately suspend any such activity to protect the fundamental freedoms of New Zealanders?
Honourable Bill English, on behalf of the Prime Minister.
Well, Mr Speaker, as I pointed out in the answer to the principal question, when an issue was raised of...
it's more important that Parliament hears this than television.
As I said in the answer to the principal question, when the matter was raised by the Inspector General, advice was given by the lawyers of GCSB and the SIS that the long-standing practice and interpretation which had been in place both prior to the GCSB Act and under the GCSB Act under the previous Labor government for 5 or 6 years, that practice was legally valid. That was not the end, however, of legal discussions. They went on for some time.
Supplementary question, David Shearer.
Doesn't he think that it's his duty to New Zealanders that as soon as he finds out that there is the possibility of illegal spying, that he stops spying altogether?
Honourable Bill English, on behalf of the Prime Minister.
When sufficient doubt was raised about that...
Rubbish.
When sufficient doubt was raised about that...
It was in September.
The Director of the GCSB took exactly that step, and it still remains in place. At the time that these matters were raised with the Prime Minister, the subsequent advice was that the activities were lawful. That turned out to be incorrect.
Supplementary question, Louise Upston.
So when was the Prime Minister first made aware that there were 88 people who may have been unlawfully being subjects of surveillance by the GCSB?
Honourable Bill English.
Mr Speaker, on behalf of the GCSB,
Order. I want to hear.
He's not very pleased with the government. On behalf of the Prime Minister, he was made aware when he received Rebecca Kittredge's report on March 22nd. Advised that Ms Kittredge was unable to confirm the number herself until the day before she completed her report. In addition, final legal advice was not received from the Solicitor General on this matter of the legality of GCSB's activities until the 19th of March 2013. Mr Speaker, it's a nonsense to suggest that the Prime Minister should or could have released information regarding the question of legality surrounding these 88 people sooner than the advice was clear and the report was completed. There was something that was this was something that was unclear. Legal interpretation.
Order.
Interpretation still remains difficult, and it would be irresponsible for the Prime Minister to raise these issues in public without full information and without clear legal advice as to the status of the GCSB's activities.
Supplementary question, David Shearer.
Why didn't he ever mention in the myriad of media interviews and public statements he's made on the issue of the illegal spying that there were red flags, as he calls it, raised in July last year?
Honourable Bill English on behalf of the Prime Minister.
This amounts to the Prime Minister saying he knew something before he knew it.
He was told. He was told.
The Inspector General raised the possibility that there were questions. The immediate answer to those questions were
That was unresolved.
The GCSB were legal because the chief legal advisors of both intelligence agencies thought that the practice they had followed under the previous Labor government, pursuant to the act that the previous Labor government had passed, were legal.
Give it, Mr Speaker.
Supplementary question, Louise Upston. Order. Order. Supplementary question, Louise Upston.
What was the purpose of the GCSB Act of 2003?
Honourable Bill English.
Publicly available information.
Order.
Got a copy there, Bill?
Order.
The Act was passed in 2003 under the previous Labor government, and its purpose was to continue the GCSB and establish it as a Department of State, because actually it already existed and it was already active. The Act was intended to codify the existing practices, and those practices included the GCSB assisting NZSIS to undertake surveillance on New Zealanders. That was known to the government of the time, never questioned by the government of the time, and nor were any questions raised about the legality of those activities when that Act was passed. Mr Speaker, the GCSB was assisting the NZSIS, which I think the House needs to be aware. The NZSIS, the Security Intelligence Service, does legally undertake surveillance of New Zealanders. The GCSB was acting as the agent to assist with their specialised technological skills.
Supplementary question, David Shearer.
Can the Prime Minister confirm that he is the first Minister responsible for GCSB who has been alerted to the potential illegal spying by that Bureau?
Honourable Bill English on behalf of the Prime Minister.
Speaker, I don't think the Prime Minister can confirm that, because he won't be aware of every conversation that would have happened under the previous Prime Minister who passed the GCSB Act, and I presume very thoroughly examined the way the Act was structured to ensure that the activities of GCSB were legal. What I can tell the member is that when the Prime Minister became aware of significant legal issues, he has taken action, and in the next couple of weeks, the results of that action will be made clear to the House and to the Parliament.
Supplementary question, Louise Upston. Order.
Why is the Inspector General of Intelligence and Security now looking into the 88 cases referred to him?
Honourable Bill English on behalf of the Prime Minister.
The Inspector General of Intelligence and Security is the watchdog that has been set up by this Parliament to oversee the activities of the intelligence agencies. The Prime Minister has written to the Inspector General and asked them to look into these cases. His office is the correct place for these inquiries to be directed. The Parliament has set out in Section 11 of the Inspector General's Act that his functions are to inquire into any matter that relates to compliance by an intelligence and security agency with the law in New Zealand. His function also includes inquiring into any matter where it appears that a New Zealand person has or may have been adversely affected by the Act, by an act or procedure of an intelligence or security agency. So the Inspector General is the correct place to refer concerns about the legality of actions of the intelligence agencies.
Supplementary question, David Shearer.
Just yesterday, the Prime Minister said that the question of the legality of GCSB was, quote, unresolved. Why did he not, with that amount of doubt, stop the activities of GCSB and its illegal spying?
Good question.
Honourable Bill English on behalf of the Prime Minister.
Mr. Speaker, the answer is the same as the answer I gave earlier. When
that was no good.
Were raised by the Inspector General and advice was taken on the legality of the actions immediately related to that. The advice from the senior legal counsel on these matters, regarded as expert, would oversee the process.
How much of it went on after July, Bill?
The advice was that the activities were legal. However, that was not the end of the legal. That was not the end of the legal discussion. As soon as the Prime Minister took the view that there was significant doubt about the legality of the actions, he, along with GCSB, moved to suspend the activities of GCSB that may have been in doubt. And I would stress the point that Member made. It's still an open question as to whether those activities are legal or not legal, and the Inspector General is going to have a look at it, and he will recommend what action should be taken.
Supplementary question, David Shearer.
Mr. Speaker, in relation to his answer, can he please answer why spying continued when the question of legality was still unresolved in the mind of the Prime Minister? Why did that spying continue when it was unresolved?
Honourable Bill English.
Speaker, because the legal advice at the time appeared to resolve the matter with the advice that the behaviour was legal. That's what.
Supplementary question, Dr. Russell Norman.
Thank you, Mr. Speaker. When issues arose in July 2012, when the Prime Minister was briefed as to some concerns as to the legality of what the GCSB was doing, why did the Prime Minister not ask for a legal opinion from the Crown Law Office?
Honourable Bill English.
Mr. Speaker, I can't give you exactly the answer on whether one was requested or whether one was offered. The advice I have from the Prime Minister is that the senior legal advisors of the agencies believed
Order.
were legal. That was not the end of the legal discussion. Advice has been subsequently taken. And as I said before, it's still an open question as to whether the interpretation of the Act that was in place under the previous government and under this government was correct or not correct. There is doubt about it. The activities of the GCSB have been suspended and the Inspector General is looking into the matter.
Supplementary question, Dr. Russell Norman.
Thank you, Mr. Speaker. Is the Minister aware of the Cabinet directions for the conduct of Crown Legal Business 2012, which state that the Attorney-General and the Solicitor-General have constitutional responsibility for determining the Crown's view of what the law is? And if he were aware of that, Given that there was a question of the legality of the GCSB raised with him in July 2012, why did he not follow these Cabinet directions and seek a legal opinion from the Auditor General, the Attorney General and the Solicitor General?
Honourable Bill English.
Legal opinions were sought, and as I answered in an earlier question, the Solicitor General gave their final legal advice on this matter as recently as the 19th of March. So in fact the government has been keen to sort out exactly what the legal issues are. It's turned out that in the light of 20 or 30 years of practice where the legality was taken for granted and the behaviour was advised as legal, it has taken some time for others who have addressed the issue to come to a view that there is serious doubt. In fact, as soon as the Prime Minister was aware of significant doubt about the legality of those matters, as soon as GCSB were aware of it, they suspended activities, and that is about 6 months ago.
Supplementary question, Dr Russell Norman.
Given that the Minister responsible, the Prime Minister, did not go to Crown Law on immediately discovering there was a question of legal interpretation as to whether the GCSB was acting lawfully, is he confident that the Minister responsible is up to the job of providing oversight of the GCSB?
Honourable Bill English.
Well, Mr Speaker, I don't go with the accept the member's assertion about what the Prime Minister did or didn't do, simply because we don't have that information in front of us. But I can reassure the member that the Inspector General raised the issue, as is his want, just quite why it came up after many years of the same practice, including after the implementation of the GCSB Act, isn't yet clear. When the Prime Minister had the view, and the GCSB had the view that there was a significant question to be answered, he took action. Again, I emphasise the Inspector General has yet to determine whether the actions were legal or not legal, and Crown Law advice on the matter has been received as recently as only the 19th of March. This has been a complex process of unravelling decades of practice and decades of legal interpretation which everyone took for granted. In fact, that member should be pleased to remember that the government has brought all these matters to the public attention and is in a position to resolve them over the next few months.
Supplementary question, Dr Russell Norman. Order, just supplementary question.
If the Prime Minister were to find out that his Minister, the Minister responsible for overseeing the GCSB, on finding out in July 2012 that there was an issue of legal interpretation as to whether the GCSB was acting lawfully, if that Minister did not immediately seek a Crown Law opinion on that matter, as he is required to under the Cabinet directions, would he still have confidence in the ability of that Minister?
Honourable Bill English.
Well, again, I don't accept the member's assertions. It is fundamentally the task of the legal advisors of the agencies to be familiar with the law, and you might assume that they were familiar with the law, having spent many decades interpreting and operating that law. And secondly, relying on the role of the Inspector General as an independent oversight of the intelligence agencies. The matter was raised with the Prime Minister. Subsequent action led to legal advice that the activities were legal. One might have assumed that resolved the issue, but in fact legal debate continued, and over some 6 months later, 8 months later, the Solicitor General produced an opinion on the 19th of March this year.
Supplementary question, Dr Russell Norman.
Does the Prime Minister, not realise that in his statement just then, he exactly restated the problem, which is he said that they should rely on the internal legal advisors within those departments, when Rebecca Kittredge in her report is absolutely explicit that the GCSB as a public service department is that it is the Attorney General and Solicitor General that have the constitutional responsibility for determining on what the law is. So by relying on those internal advisers, he did not follow the position that is in the Cabinet directions for the conduct of Crown legal business.
Honourable Bill English.
Mr. Speaker, of course, Ms. Kitteridge's report is correct in laying out that process. When there was reasonable doubt, when there was, when the question became reasonably significant as to interpretation, then certainly other authorities were contacted and became part of the discussion. The fact that the Inspector General mentioned the issue and that it was fundamentally his job to oversee it, and that the legal advice at the time from the agencies was that the activities were legal, may not have constituted a reason to get independent advice right then. But I can't give the member the exact timetable, but Crown Law were engaged. Crown Law took many months actually to produce an opinion because it's a difficult technical area of interpretation. When there was any reasonable doubt, then the GCSB suspended its activities. And the key point here is that the participants couldn't know about the mistake before they knew. When they became aware that there was reasonable doubt, they acted appropriately to protect the constitutional interests of New Zealanders.
Supplementary question, Dr. Russell Norman.
Does he have full confidence in the Inspector General of Intelligence and Security and full confidence that the Inspector General can provide adequate oversight of the GCSB?
Honourable Bill English on behalf of the Prime Minister.
Mr. Speaker, yes, that's a statutory role, and that is why the Prime Minister has acted consistent with the statute and referred these cases to the Inspector General to make a determination.
Question number 4, Tim McIndoe.
Thank you, Mr. Speaker. My question is to